you, Mr. Chairman. Mr. Burke, I want to follow up on your comments on first to file.
Yes.
I have spoken to a lot of people about this, and I am told that a lot of our actors act as if first to file is already in place, particularly people who are operating internationally. And so I'm interested in hearing your comments on the impact of moving to a first to invent system if people are in fact already acting as if we have a first to file system. Can you comment on that?
Well, so I think you're certainly correct that internationally people have to take into account the fact that most countries are first to file. And there's no question that in some ways it would be cheaper and easier for everyone to be first to file for those companies that are doing that. But within the United States, as Professor Crouch mentioned earlier, this is going to have a very disruptive effect on domestic patenting. And on companies that are primarily focused on domestic patenting. We're going to have to figure out what all these terms mean unless they're very carefully defined. And so that's the disruption that I mentioned.
And what about the major tech companies that are doing business internationally? Are they already acting as if we have a first to file?
Well, they certainly are internationally in thinking about when and where to file, right? But again, domestically, when they file in the United States, there are all kinds of provisions in Section 102 and 103 that they will have to figure out what that means in the U.S.
Some of the testimony that we've heard has basically said that with a first to invent system, you're disadvantaging smaller businesses because they don't have the resources or the funds to be in prolonged litigation. And if we go to a first to file, then that will somehow help in that area. Can you comment on that? And that's for all three of you.
I think it's very difficult to assess that. There are arguments both ways. I've both heard that first to file disadvantages small businesses because they don't have the resources to file as quickly, and then I've heard that first to invent disadvantages small businesses, as you indicated, because they don't have the resources to be tied up in interferences and other kinds of litigation. So I think everyone is guessing at that. What I do know is...
Can I stop you there for a second?
Sure.
And I don't know if you're familiar with this, but the witnesses who testified previously in some other hearings, one in particular cited some studies, a Hastings Law Review study, and where they had gathered data on litigation. And, you've probably seen those. If you haven't, I would certainly commend that to you, because it sort of convinced me to some extent that they weren't guessing, that they had some data to back up their argument on that. But I welcome your comment on that.
No, you're absolutely correct, Mr. Griffin. I mean, people have tried to gather some data. There's also data that goes the other direction, and I think the data we have is inconclusive. So I'm not sure whether it will advantage or disadvantage small businesses. What I do know is we will spend the next decade figuring out what that means for domestic patent law, which, as I said, is going to be great job security for my students, but it may or may not be good for businesses.
Sure. Do you all want to comment on that particular?
I have a quick comment, there's no way that I will be able to convince people to change the name of this away from first to invent versus first to file, but the change that occurs is not really about the patent race between two entities, right? The biggest change for most patent applicants is that under the current system, there's a potential to focus on your invention date, which is sometime in history, versus focusing on your filing date. And if we look at what the Senate has passed, basically we've taken some amount of prior art that didn't used to be prior art under the old system because you could claim back to your invention date. And now, if we go to first to file, there's going to be a lot more prior art. That's everything that came out from the day you invented to the day you filed. And all of that can be used against you, not just in litigation or these protracted battles, but just when you're trying to get your patent through the patent office. And the patent office can find those and make it easier to invalidate the patent. I
want to get one more question in. You can answer it. My time's about up. Looking at the universe of decisions, and that's really what this hearing's supposed to be about, can you identify particular decisions that have either positively or negatively impacted certain sizes of business, small business versus big business, and what that impact has been? Because as we've gone through this debate, we've heard a lot about the impact of changes in the law on either small business or big business, businesses with resources, those who don't have them. So if there's anything in particular that any cases you'd want to point out, love to hear it. Thank you, Mr. Chairman.
I think that the decisions we've been talking about, eBay, the damages decisions, the willfulness decisions, the venue decisions, all go to the burden on defendants. And I think those defendants can be large or small. There's certainly, I know, in the committee's past hearings on this issue over the last 6 years, there have been a number of small businesses that have said that they were victims of lawsuits either by NPEs or by others and just had to settle because they couldn't afford to defend them under the rules that existed. And now that playing field has been leveled in a way that hopefully they can afford to defend them.
Thank you, Mr. Griffin.